Good morning and welcome to the Public Service Commission of South Carolina. We are here this morning for oral arguments on a motion in docket numbers 2023-38-E and 2023-39-E. Let's take a roll call of commissioners. Present in the hearing room, we have Commissioner Justin Williams, Commissioner Thomas, Commissioner Carol Lee Williams, Commissioner Caston, Chair Belser, and with us virtually we have Commissioner Irvin. I note that Vice Chair Powers is not participating today. He missed the earlier hearing and therefore is not, under the rules, is not allowed to participate going forward in these two dockets. I'm going to recognize Ms. Moser to read the docket for us, and then we'll take appearances.
Thank you, Madam Chair. Good morning, commissioners and parties. We are here today for the proceeding in docket number 2023-38-E regarding the South Carolina Office of Regulatory Staff's petition for a declaratory order, and docket number 2023-39-E, the petition for a declaratory order of Pinegate Renewables, LLC, and Catalina Solar, LLC versus Dominion Energy South Carolina, Inc. The proceeding has been scheduled for today, September 25th, 2023 at 11 a.m. pursuant to Directive Order number 2023-715. All parties participating in this matter are available and the docket is in order. Thank you.
Thank you, Ms. Moser. Let's just take appearances of all the parties. I'm going to go with petitioners first. We have, who's representing the Office of Regulatory Staff?
Thank you, Madam Chair, members of the Commission. Ben Muskin on behalf of ORS.
And for docket 2023-39, petitioner Pinegate Renewables and Catalina Solar.
Charlie Tereni and Bland Hallman.
Thank you. And then respondents, I'm not going to list Pinegate again. Dominion Energy South Carolina.
Matt Gissendanner on behalf of Dominion Energy South Carolina. With me today is Ashley Cooper of the Baker Donaldson Law Firm.
Thank you. Carolina's Clean Energy Business Association.
Madam Chair, good morning. Taylor Spear and my law partner Ben Sweeney for Carolina's Clean Energy Business Association.
Good morning. South Carolina Coastal Conservation League.
Good morning, Madam Chair, Commissioners. Kate Mixon on behalf of South Carolina Coastal Conservation League. Ms. Clancy had a conflict today, so will not be appearing.
Thank you. Duke Energy Carolinas and Duke Energy Progress.
Good morning, Madam Chair, Commissioners. On behalf of Duke Energy Carolinas and Duke Energy Progress, I'm Sam Wellborn, and with me is my co-counsel, Frank Ellerby of Robinson Gray.
Thank you. And we had communication, I think, that was served on all parties from South Carolina Public Service Authority that Mr. Pelcher had a conflict and would not be able to appear today. Did I get everybody? Okay. We're here this morning on a motion filed by Dominion. So, Dominion, you're recognized.
Thank you, Chair Belser, members of the Commission. First, before I start my motion, just would like to thank the Commission for the opportunity to discuss this matter, to review it with you for the prompt action in hearing and arranging for this morning's hearing. So, as made clear by Dominion, it came into evidence on September 5th. Plant Eastover Solar, it's owned and operated by Pinegate, had an interconnection limit of 73.6. Mr. Sharp, James Sharp, who works for Dominion Energy, he works in the transmission department. He works in they have a solar desk that helps, or a renewables desk that they set up to help integrate renewables to their system. And he was on the reliability portion of this desk, and he looked over and he noticed the output of Eastover exceeding its interconnection limit of 73.6 and then exceeding 75 megawatts. At that point, he called over to Pinegate. Pinegate, in his conversation, these calls happen with utilities on recorded lines, as you all know. And FERC requires much of this to be on a recorded line. So these these conversations are taped, they're maintained. He has a conversation and the person says, well, we're way over. I don't know what happened. He doesn't know whether this is going to continue to keep going because he knows it's 103 DC capability. So he needs an answer. Well, so later he calls back and says, hey, following back up, do we know what happened? There was still no answer. So then later, Jay Cole, who works at Dominion in the transmission department also, who is the person who administers interconnection agreements. He negotiates interconnection agreements, handles the terms and conditions of an interconnection agreement. He emails Pinegate, again, to get an answer as to what happened. In that email, Pinegate acknowledges that they exceeded their interconnection agreement and they exceeded 75 megawatts. So the first part I'd like to point out to the commission is we have this newly acquired evidence, and there's no dispute between the parties as to this evidence. I mean, we know these ratings. We have recorded phone calls that acknowledge the ratings. We have email correspondence that acknowledge the ratings. So this is not a situation of someone saying, well, how reliable is it? No, we know it. We've all agreed, in fact, on these readings. So the question then before you is this truly after acquired information that's relevant to this proceeding? We believe it is, because we believe that the testimony you heard was repetitive in the trial. It was consistent in the trial, which was, we will not exceed our inverter limits. We simply can't exceed our inverter limits. And if you look at Dominion's reply, we quote a lot of the testimony from the hearing, right? I'll read it to you. Witness Hopkins' statement that the utility would have to receive and approve a request. Witness Hopkins and Secra said that the installed inverter cannot export higher than its maximum capacity, right? Witness Levitas, it's undisputed that exceeding a facility's output limitation specified in its interconnection agreement would subject the owner-operator of the facility to dire consequences. These were his quote at the hearing. Witness Hopkins confirmed that exceeding capacity limitations in IA could result in possible financial penalties, disconnection, etc. What we're not here today is to talk about the penalties, okay? So whether this happened in testing mode, whether this was a violation of the interconnection agreement, that's not before you. What's before you is, and the reason Dominion has brought this to your attention is it finally has newly acquired information that says, no, wait a minute. The DC rating was 103. It not only could, but did exceed its AC limited rating. This is newly acquired information that directly contradicts testimony put forward by multiple witnesses that says we can't because we have inverter limits, we can't because we have an interconnection agreement that says this is what we're only allowed to do. Dominion's position has been pretty clear throughout this proceeding. Dominion's position was, look at the original statements made by Pinegate in Sasiba, which says solar plants are traditionally overbuilt, and then you use an inverter to limit the output. So when the Siting Act says to you, take a pre-construction look at the design for capability of a plant, that's what you look at. And that's what these facts have shown. When you look at the pre-construction design for capability of this plant, it was 103 megawatts DC. It was well in excess of the inverter limits. And the facts that came to light on September 5th prove that. And there's no dispute regarding those facts. Thank you very much, Commissioners.
Thank you, Mr. Cooper. Pinegate. In case y'all ask the order, I'm going in the order that petitions to intervene were filed.
Thank you, Madam Chair. Bland Holman on behalf of Pinegate Renewables. Like Mr. Cooper, would like to thank you for the expedited schedule in resolving this important matter. Appreciate your attention to it. As submitted in our response, we think the motion should be denied. There's two reasons. First is relevance. Whether or not a facility has exceeded its designed operational AC capacity is just not relevant to whether or not the commission should change the settled understanding that the Siting Act applies based on AC capacity. Second, transient exceedances that occur in testing and commission do not define a facility's designed operational capacity. Instead, this kind of testing allows the facility to be configured to ensure that the actual operating conditions conform to the designed operating capacity. That's the whole point of testing. Now, Dominion has, I think, misapprehended our point about testing in its reply, a very far-ranging reply that was filed last night. I want to be clear, we are not suggesting that what happens in testing can be ignored. The opposite, in fact. The point of testing is you have to very carefully look at what's going on so that you can adjust and make sure that the facility, when it goes into commercial operation, will not deviate from its parameters, including its nameplate capacity. And this is not an IKEA bookshelf. Okay, a solar facility is a complex, very large machine, thousands, if not millions of parts, components and connections, different components transported from various locations, multiple crews installing different components over many months, and complex interactions and feedback loops of the systems like the panels, the trackers, the inverters, the plant controllers, and interconnection facilities. That's why you do the testing. You set this thing up and you check for equipment failures, incorrect installation, unexpected feedback loops, performance problems. And in this particular instance, the testing has worked in the sense that we have corrected the problem. And so the testing is very important. And we've determined that the root cause here was that the equipment on site was not properly configured. And it was not installed in a manner that was consistent with the way it was designed to operate, which is the key test under the Siting Act. I'd like to point out very briefly 2 points where we agree with Dominion. First, on page 1 of their reply, Dominion says, this proceeding is focused on the Siting Act, specifically determining the best measure of a generating facility's designed for capability. That's the key metric here. And that we agree with that, and this facility was designed not to exceed 73.6 megawatts at the point of interconnection. That's what the interconnection agreement says. That's what our engineers designed it to do, and that's what we understood it would do. Something happened, and it needs to be corrected, and it has been corrected. Second, on page 6 of Dominion's reply, they say, clearly, all parties intended and expected for the facility's capacity to be limited in a way that complied with the interconnection agreement, regardless of whether the project was in testing mode. Now, that's correct as well. All parties did intend and expect that the facility's capacity would comply with the interconnection agreement. And so we think the motion should be denied because it's really not material to the point in front of you, which is this AC-DC question. And here, remember, we're talking about an exceedance in AC. And if anything, the issues that have been raised go to, as Mr. Cooper said, there's the interconnection agreement, there's the PPA, there are a lot of different legal structures here in place where this is properly dealt with if there's an issue, but it doesn't really get to the Siting Act and whether or not the facility was designed to have a capacity, an AC capacity more than 75 megawatts. Thank you. Happy to answer any questions.
Thank you, Mr. Holman. Sasiba?
Thank you, Chair Belser, Commissioners. I also want to repeat the fact that CC appreciates very much the Commission scheduling this matter on a very expedited schedule. We also want to avoid any sort of further disruption in the decision of this case. We submit that Dominion's motion should be denied for two reasons. First, the evidence that they have provided is not inconsistent with what was presented at the hearing, but is cumulative of that. And second, as my colleague, Mr. Holman, said, this evidence is not, I understand why the commission may have an interest in understanding more about the facts and circumstances relating to the Eastover project, but it is not relevant to the issue that the commission is being asked to decide in these petitions. Dominion's motion introduces evidence that the output of the Eastover solar facility briefly exceeded the output limitations under the interconnection agreement. It shows that Dominion immediately detected that exceedance and contacted the project about it. It also shows that Pine Gate or its contractors corrected the problem so that it would not recur. These things are uncontested. The affidavit from Pine Gate shows that when the exceedances occurred, the facility was not operating, as Mr. Holman says, it was not operating as it was designed to do. There were problems with the equipment at the site. The manufacturer was testing and calibrating the facility to ensure that when it did reach commercial operation after commissioning, it would function properly. And this includes complying with the output limitations under Eastover's interconnection agreement. This is nothing new. CCBA, CCL, Pine Gate, and Duke's responses to Dominion's motion all cite testimony from the evidentiary hearing acknowledging the possibility that if there were problems at a solar facility, that facility could temporarily and inadvertently export more than the limits that were in its IA. Dominion does not dispute this in their reply. In fact, their reply brief just doesn't discuss this testimony really at all. Mr. Cassis testified at the hearing that he was aware of several instances in which solar facilities had gone over their interconnection limits. Commissioner Carolee Williams asked Mr. Hopkins about this. That was Pine Gate's witness. Mr. Hopkins acknowledged that it was possible for a solar facility to export sort of more than its interconnection limit. And he testified that he would expect the engineering team and the manufacturer of the equipment to correct the issue and make sure that it wouldn't recur. Again, this was discussed at the evidentiary hearing. Commissioner Caston also asked Mr. Hopkins about this testing and commissioning process. And Mr. Hopkins testified that the equipment manufacturer almost always has to make adjustments to inverter settings during this process so that the facility would function as it was designed to do. And this is not unique to solar projects. It's why the interconnection procedures and the interconnection agreement require all generators to undergo testing and commissioning. Eastover's PPA requires this testing as well. Mr. Thatcher from Duke also provided testimony about how and under what circumstances the equipment manufacturer would make adjustments to inverters. There's no inconsistency between the testimony that was provided at the hearing and what happened at Eastover. Eastover, as has been discussed, was in testing and commissioning. The manufacturer was making adjustments, and there were problems that resulted in exceedances. What's critical is that the facility at that time was not functioning at the designed for and capable of operation capacity. And Dominion detected those exceedances immediately and took the action that it deemed appropriate. Again, this is all just theme and variation on what the witnesses from Pine Gate and Duke said at the hearing. It is cumulative evidence, and there is no reason to reopen the record to bring it in. Again, it is irrelevant because, as Mr. Holman has said, and as Mr. Cooper also said, the applicability test under the Siting Act is what's the capacity that the facility was designed for, right? The pre-construction design for capability, as Mr. Cooper said. I don't think there's any dispute that the Eastover facility was designed to operate at a capacity of less than 75 megawatts. We're at the capacity that was dictated by its interconnection agreement, but it simply failed to do that because of equipment problems and as part of the commissioning process. So the applicability test of the Siting Act is not whether a facility could, if there was an equipment failure, ever put more than 75 megawatts on the grid, however temporarily. The General Assembly, I don't think, was trying to play gotcha with the Siting Act. They told the commission to look at what the facility was designed to do. Eastover wasn't doing what it was designed to do. So if even if you do reopen the hearing, all that the evidence is going to show is that at one solar facility, there was a temporary equipment failure that led to a very brief exceedance of the 75 megawatt limit. For those reasons, we submit that you should deny the motion. Thank you.
Thank you, Mr. Snowden. South Carolina Coastal Conservation League.
Thank you, Chair Balser. I just have a few brief comments to add. At the outset, I want to just remind the Commission of Dominion's argument in this proceeding, which is that solar facilities are designed for and capable of operating at their DC rating. And
Ms. Mixon, can you hear me?
hear you.
You froze. You may need to start again.
Okay, are you able to hear me now?
Yes, ma'am.
Okay, thank you. I'll start over and just say, just as a reminder of Dominion's argument in this proceeding, it's that solar facilities are designed for and capable of operating at their DC rating, and that DC rating should therefore govern whether those facilities are subject to the 75 megawatt threshold in the Siting Act. But Dominion's motion doesn't put forward any evidence that supports this argument. The Pine Gate facility that was in testing has a DC rating of 103 megawatts. Dominion's motion doesn't have any evidence that shows this facility, or any solar facility for that matter, was actually designed for or capable of operating at that DC rating. In fact, Dominion only even mentions the facility's DC rating one time in its motion. At most, Dominion's motion presents evidence that one facility, due to a manufacturing error that departed from the facility's design and was quickly discovered and corrected during testing, had an actual AC capacity that exceeded its designed for capacity, and therefore the 75 megawatt AC limit in the Siting Act. But this has no bearing on whether the Siting Act threshold should be changed from 75 megawatts AC to DC. And it shows yet another example that Dominion has been operating under an understanding that the Siting Act applies to solar facilities that exceed 75 megawatts AC capacity. Despite this, their motion and reply again seem to insinuate that Pine Gate and solar developers are trying to evade Siting Act review. But this project, with Dominion's approval, moved forward because its design was under 75 megawatts AC. People don't get tickets for going the speed limit. Let's say one person's car had a manufacturing error on the speedometer, and the driver thought they were going the speed limit when they were actually going a couple of miles per hour over. If they got pulled over, the question would be whether or not that person should get a ticket. You wouldn't look at whether you need to reset the speed limit. As every other party has already argued at length in this proceeding, if any facility were to intentionally misstate or change its design to increase its capacity beyond 75 megawatts AC, that is an issue for Siting Act compliance or enforcement. It has nothing to do with this proceeding, which is what the Act's jurisdictional threshold is. For those reasons, Dominion hasn't put forward any new evidence that is actually relevant to the question presented in these proceedings, and we ask that the Commission deny their motion to reopen the record. Thank you.
Thank you, Ms. Mixon. Duke Energy Carolinas and Duke Energy Progress.
Here we go. Thank you, Madam Chair. Frank Ellerby for the Duke companies. Once again, coming at the end of these arguments, I will try to offer you something that hasn't already been said by my colleagues. We also, Duke companies also oppose the motion to reopen the record. We believe this evidence is cumulative and irrelevant. there was an exchange. I think Commissioner Caston asked the Duke witness, Russ Thatcher, about the inverter. And I believe the question was, I don't have the full transcript, but I believe the question assumed that when you were putting a facility like this in place, you would go and get an off-the-shelf inverter that had a specific rating. And Mr. Thatcher explained that it didn't work that way. And that the inverter, I'm going to quote now from his testimony at volume 2 of the transcript, 231, 232. The inverter has a physical maximum amount of electric current that can go through it, and it can be adjusted by the manufacturer, and often that's indeed how manufacturers sell different models of inverter. It's the same hardware, they just have different firmware ratings that are set by them. And that's what happened in this instance. The Eastover project, as I understand the affidavits that have been and the exhibits that have been submitted to y'all, they were replacing inverters. They were going through the process of the manufacturer of the inverters installing and adjusting and getting the inverters operating the way they were supposed to be operating. That's absolutely in line with all of the testimony that y'all heard from witness after witness, that the inverters are adjusted in order to get to the design capacity of the facility. And that's, y'all heard us make the argument over and over again. The Siting Act is focused on the capacity of the facility, the generating facility. And with respect to a solar facility, that's the panels, the inverters, the substation, all of the equipment, that's the facility. It's designed because the inverters are brought in, the firmware is adjusted so that the capacity will be below 75 megawatts. In that instance, that facility has a design capacity less than 75 megawatts. The Siting Act does not apply. AC has been, continues to be the appropriate measuring stick. That's how, as we've talked about in July, that's how this commission and the parties measure and compare one type of generation with another. If you inject DC into it, you're doing something that the General Assembly did not have in mind when they passed the Siting Act and just create confusion. And our position on this is the same we took since we first briefed the issue of possible manipulation back in June, which is if that happens, the utilities monitor it. This incident does show that the utilities monitor accurately or are able to monitor that type of thing effectively, which is what we told y'all back in June, and that's a different matter. It doesn't divest the commission of jurisdiction. Y'all can take action if a utility brings that to you. So for those reasons, we think the motion should be denied and y'all should move forward to issue a ruling. Thank you very much.
Thank you, Mr. Ellaby. Office of Regulatory Staff.
Thank you, Madam Chair. ORS does not take a position on the motion.
Thank you, Mr. Mustian. Mr. Cooper,
Chair Belser,
brief reply,
Yes, thank you.
and then we'll see if commissioners have questions.
Thank you very much, Commissioner, members of the commission. I want to talk to you about a couple of things that were said. One is my name was called a few times saying that I talked about the standard of being designed for, but I also said designed for or capable of. Those are the words in the Siting Act. Siting Act doesn't just say designed for. Siting Act says capable of. I think somebody said, oops, we went over for just a little bit. That means it's capable of doing more. There was an example of a car, and what if you were speeding? I've got a real life example for you. I had a new car. I took my son dove hunting. Afterwards, I said, why don't you drive us back home? But I want you to put cruise control on. We were on I-77 coming back. I'm watching, looking at my emails, and I look over, and my young son, who's good kid, good boy, is going 85 miles an hour in my car. Is my car capable of going 85 miles an hour? Or is it only capable of 75 because that's what I told him? And if I went into traffic court and I said, Judge, he only briefly went 85, oops. You think the judge would think I took it seriously? I think the judge would say, you know, these are laws that we have to enforce, and you're coming to me saying, oops, my son just briefly went 85? I don't think the judge would take that. I want to also clear up this idea of testing. This plant declared commercial operation on April 27th. It had been operating. It may have had issues, but it was operating. We also have an email that was from Pinegate. This was the person who followed up with Dominion, and he looked into this. Look at what his words are. He says, PV inverters are hard limited. However, we discovered that a few PE inverters overshoot that day. It was just a typo. He meant overshot that day. We already asked PE to return their gain setting to avoid this overshoot. Regarding why the PPC didn't limit site output to 73.6 megawatts, we traced the issue to 2 quantity inverters that were running in manual because they previously faulted. He didn't say anything about testing, did he? He gave you some examples of what happened. The fact of the matter is, we're here because the Siting Act is a pre-construction examination of a plant's capability. And this shows what this plant was capable of. Even if it just briefly went over the speed limit, you know what it's capable of. Thank you very much.
Commissioners, questions? Commissioner Carolyn Williams.
Thank you, Chair Belser. Is it appropriate for me to just ask questions and hear from each of the parties as they wish to procedurally?
Go ahead.
Okay. We'll see how this goes. Some of them will be for you all particularly, and others will not. I'm interested in understanding better the differences between commissioning and testing. Attorney Cooper just talked about testing, I think, but it's also been talked about as commissioning. But you referenced the April date of starting. So can someone kind of share the differences in those two? Is there a difference? I'm reading faces right now.
I'm happy to. I don't know if you directed that to anybody, but I'm happy to. I think, Commissioner, two things I would say is it's really important to understand the difference between an interconnection agreement and a power purchase agreement. Mm-hmm. They have two very different functions, as you know. An interconnection agreement is what allows a plant to tie into the grid, and it's focused on the safety of the equipment, the safety on the grid. So an interconnection agreement provides a limit. In this case, it was 73.6. That limit is always there. It doesn't matter whether you're in testing mode, whether you're in testing, whether you've reached commercial operation, whether you've hit COD. That interconnection agreement is there. So even if you buy the argument that this was in testing, it would allow them to come and get as close to that interconnection limit as they could. But that interconnection agreement is there always. Mm-hmm. The power purchase agreement is a separate document, and that is Dominion buying power from that facility. That's where it comes into what are your obligations to perform? Have you satisfied your conditions precedent? Do you have to start meeting requirements? And if you're in testing mode, well, maybe you don't have to meet some of these requirements. But if you've reached commercial operations, in terms of how much energy you provide to us in satisfaction of our need and our negotiated purchase of energy, this doesn't have to do with interconnection limits at all. This is simply about we have purchased and you're going to provide for us so much so we can use to provide our customers. If you're going to send us schedules, and so if you don't meet your schedules and you come up short, well, then there are liquidated damages. There are other performance guarantees. So testing in commercial operation really goes to those negotiated or transactional portion or provisions related to the purchase of energy, not about the interconnection limits themselves. The interconnection limit always applies regardless of what sort of testing phase you're in. It's just that on the power production side, you might be excused from certain performance guarantees if you're in testing mode. Does that make sense? They have to reach a certain amount. So in other words, when you sign a PPA, you don't want a plant that performs 60% of the time, right? You're actually saying, hey, we want your plant. If you're going to tell us that your plant can send us 73 megawatts, we want you to be able to send that, say 95% of the time, because that's when that's how we schedule it. That's how we know you're going to do it. And if they fall below that, then they're subject to penalties. Well, they could come and there's negotiated provisions like testing, which says, okay, hang on, if we've got to do something like that and we fall well below, you shouldn't count that towards us being eligible for penalties. That's a whole different, has nothing to do with what we're doing here today.
Okay.
I hope that helps.
It does. And I see Attorney Holman's ready to go. And I want you to, but I think the clarity, one piece of clarity I want is someone did it, both terms have been mentioned. So despite the separate agreements, please clarify what was actually happening.
I will give it my best shot. And I think the point is commissioning is like commissioning a ship.
Mm-hmm.
You know, it goes out and it is now in service. The testing is what you do to ensure that before this thing is commissioned and operational, that it's not going to sink. That's the testing you do before you commission the machine to operate. So that's the difference. And these exceedances occurred during the process of testing so it can be commissioned. Now, I'll just say the people who conduct the testing are called commissioning agents and that kind of thing. And so there's a little bit of an overlap there, but that's the general difference in testing and commissioning as I understand it. Now, I'd like to address, if I could, go ahead.
Thank you for reading my face. But when was Eastover put into service?
Thank you. That was what I wanted to address. Mr. Cooper said that the plant was in commercial operation April of 2022. That is true and also incomplete, because what happened was in May of this year, this facility experienced operational challenges and had to declare a force majeure, which took it offline. And in fact, as Mr. Cooper presumably knows, there's now a new PPA and a new commercial operation date. And that commercial operation date is November 30th, 2023. I said 2022 earlier. I meant 2023.
For April 2023. Okay.
Yeah, so this is a little confusing, but the facility was in commercial operation and went out of it and has had to be fixed. And inverters been reinstalled, and that's why we're back in testing and commissioning, headed towards that commercial operation date of November 30th.
Sure. Commissioner Williams, may I briefly further elucidate that? Mr. Holman is correct. Their Eastover facility entered commercial, gave us a notice that they were in commercial operation on April 27th. Shortly thereafter, as he's indicated, there were several, we call them operational incidents or fires with inverters that caused Dominion Energy to raise the question to Eastover whether, in fact, they had, in fact, met the conditions for commercial operation. There was a dispute about that. At no time has Eastover, in the course of that dispute, indicated that they were not, in fact, in commercial operation. As a result of that dispute, we entered into I believe it's a second amendment to the Eastover PPA that was signed on Friday, and I believe he is correct that as part of that agreement, so that we would not continue to argue over when commercial operation began, we have reset some of the dates. But the point that Mr. Cooper was making is that they had indicated that they were in commercial operation on April 27th. Now, prior to that, under the PPA, before you enter commercial operation, there's a completion date. It's 30 days prior to that. That's when you, as I understand it, you complete construction, and then you go through a testing phase, and you can test. You're still not going over this interconnection limit that you have, but you go in through a testing phase under the PPA, and only then, once all of that is complete, is when you would declare that you were in commercial operation. Eastover did that the first time. That's now been withdrawn as a result of the settlement, which will be filed with the commission later this week. But Eastover did that on April 27th and said that they were in commercial operation, which assumes that testing is complete. They're in commercial operation. And then we had this dispute because there were operational incidents with the Eastover system.
Several of you mentioned that this was cumulative. Would you expound on what that meant? And I think, Ms. Mixon, you were one that referenced it, and somebody else early on talked about the cumulative impact.
Chair Williams, I think it was CCBA that discussed the cumulative evidence in more depth, but I will just say I think the kind of thrust of that argument is that Dominion has only presented evidence here that shows points that have already been made earlier in the proceeding, namely that there was never any dispute that a solar facility might be capable of exceeding 75 megawatts AC capacity. In this case, again, it was because of an error in the inverters that were installed at the facility. But that is, again, not something that has ever been in dispute. And it just does not get to the central issue of this proceeding, which is what the Siting Act threshold should be.
Commissioner Williams? I'm sorry, Attorney Mixon, for interrupting you. Were you finished?
Yes, I was just going to defer to CCBA's counsel for anything to add. But.
Yes, ma'am. Commissioner Williams, I have a question that's directly related to that question. I just wondered if you mind if
I'm open to it. I'm also aware that Attorney Snowden is ready to answer the question too. So,
and I think it may be helpful for everyone.
Go ahead.
I understand the motion is being offered based on new evidence, but I would like to hear the parties discuss what they consider the new evidence, and it's probably most appropriate for Dominion, and the other parties may have comments as well. Is it the new evidence specifically what happened at Eastover directly related to that facility, or is the new evidence more towards the possibility of what was referenced by Mr. Cases, that there have been instances that these facilities have operated over the limit or the number that they put in their PPA?
Commissioner Williams, if I may, I would characterize the testimony from the hearing as such. Mr. Hopkins and others testified that in the normal course of operations, the PPC or the inverters at solar facilities limit the output of those facilities and ensure that they don't go over interconnection limits or whatever limit sort of is relevant. But there's an asterisk there, right, which is acknowledged at the hearing, and that is that, as Mr. Cass has testified, there are circumstances in which, limited circumstances in which that doesn't happen. Mr. Cassis wasn't too specific about that. He said, well, there's some examples. Mr. Hopkins, I believe it was Commissioner Carolyn Williams, they discussed that, and Mr. Hopkins acknowledged, well, if there was an equipment problem, this could happen. If there was a design problem, this could happen, and I would anticipate that the equipment manufacturer and the project's own engineers would swiftly act to correct that. This appears to be what has happened here, so I would say that the evidence with regard to Eastover does provide an example of a situation that was acknowledged at the hearing could occur. So yes, it's a specific example, but it's not contrary to anything that was said at the hearing, and that is why we believe it's cumulative.
On behalf of Dominion, I would say that, first of all, I would say that I was not aware that some of counsel is conceding that at the hearing they made it clear to you all that they were capable of exceeding 75 megawatts based on a DC rating. I don't think that ever came out, but I'm glad that's on in front of you now. That's helpful. We believed it was new information. Commissioner, this plant provided new information to the broader context that would be helpful to the commission in deciding this issue. The reason why we believe it's new is because we had testimony of witness Hopkins, and he says, if facilities inverters are designed to limit AC capacity of a facility, it is not capable of exceeding that capacity. That was his testimony to you. Well, this is demonstrative evidence showing you, in fact, it is, if it's got a higher DC rating, it is capable of exceeding this rating. And so that's why we believe it's new information. We feel like it's material to providing you complete information so you can make the best decision in this matter. And, you know, candidly, Commissioner, we have an obligation that if we have new information that we think could be helpful to you, there's an obligation to bring that forward and allow you to make that decision for yourselves, and that's what we've done here.
Commissioner, it may be helpful to refer to CCBA's brief. I believe it's around pages 3 and 4 of CCBA's brief where we cite the hearing testimony that we're referring to here. And so on page 4 of our brief, Commissioner Williams, you asked Mr. Hopkins about Mr. Cassis's testimony about instances where the transmission team had reported the amount of energy going over nameplate capacity, and then Mr. Hopkins acknowledges, he says, thank you for the question. There may be some reasons. I think probably would primarily come down to improper design, and it would be corrected. So that is the testimony that we're referring to here. So I believe Mr. Hopkins acknowledged that possibility.
Thank you.
Okay. If I may, I think it's also worth noting if in Duke's brief, it is pointed out that it is not proper to reopen the record to introduce evidence that is merely not just cumulative or impeaching. So effectively what Dominion's evidence is, the purpose of Dominion's evidence, according to Mr. Cooper, is to impeach the testimony of Mr. Hopkins, and that is not a proper purpose for the record to be reopened. And that's the McCabe versus Sloan case from the South Carolina Supreme Court.
I see a lot of fingers on attorney.
If I may just add,
Yes.
just to respond to the question, I felt like there was maybe some talking.
Mr. Holman, please pull that microphone a little closer, please.
Maybe some talking past each other, but the key thing is, you know, you design, engineer, you heard from an expert who designs these plants. They design them to operate in a certain way. And then when, you know, there's the as designed and then there's the as built. And like I was saying, you put 1 million parts out in the field and you put them all together, sometimes the plant doesn't operate as you intended for it and designed it to operate. And so you need to adjust it and deal with that in the field. That's what, I think that's what the testimony at the original hearing, these things occasionally happen. Mr. Hopkins said, and then you go back and you change the design or the equipment to make sure that it doesn't happen again. And so that's what's happened here. And so this seems like an example of that testimony.
Understood. And Commissioner Williams, I'm going to turn things back over to you. The point I was just trying to make clear or come to some level of decision in my mind is whether or not the information as offered is new because we didn't know it at the time of the hearing, because we didn't know that. So arguably it could be new, or is it new based on a concept that we didn't know? And it seems that we knew that not only did the company's witness testify that there were instances of going over the nameplate capacity, but Mr. Hopkins testified to the fact that if that's the case, then there's a course of action to address that. So that's the only point. Whether or not the action, what actually occurred, is if that's what's new, or is it the concept surrounding it, the new information presented to the commission for reopening the case?
We would submit it as an example of facts, of concepts that were already introduced in the record.
And Commissioner Williams, I would say if you review Dominion's reply brief, it's fairly clear that they are saying, well, this information just confirms what we already said. So it is not a new argument or concept, but it is a re-argument of what was argued before.
Commissioner, if I may, it's proof, concrete, irrefuted proof of what we said. Our witness Cassis, said, I believe there have been times. I think it's possible. We're saying here is new evidence we just acquired after the hearing that demonstrates, and nobody is challenging the validity of this evidence. And that's why we wanted to put it in front of you, so you had that as well.
As a non-lawyer, I understand that this really is about the new evidence, but I'm struggling with, and y'all are just going to have to tell me if this is inappropriate to ask this, but I have 3 remaining questions. One is, why did Dominion offer this motion at the time that you offered it?
Well, it happened, Commissioner, in September. We, Mr. Sharp, who's with me today, immediately, first of all, there wasn't some like immediate alarm. He just happened to see this. Okay, so there wasn't some, like we've all agreed, there's an immediate acknowledgement. He just happened to be on the desk. He happened to look up. He happened to see this and said, whoa, this is way over. I got to see what's going on. So he calls over. He called. There was no explanation. They said they would call him back.
Got it. Understood.
He calls back again.
Understood.
Nothing happens. So if we filed this motion right after that, what happens if you want to hear some people that really get excited and start using my name? What if there was an explanation for what happened and there was something we weren't aware of? You'd hear plenty. I mean, you've already heard my name mentioned a lot today. It'd be really moving. So we waited, and we finally got an email from them the morning of that said, here's our answer to you, and we promptly filed our motion. So that's why the timing is what it was. I mean, you just have to we believe this was material evidence that the commission should hear, but we also wanted to hear back something from Pine Gate to make sure, we didn't make a representation to you that we felt was in error.
Thank you. And there was also reference to this having been noticed immediately and that the impact was brief. Could somebody clarify that? Perhaps it would be Mr. Holman or somebody from Pine Gate's team.
Well, just judging by the tables that we saw in Dominion's submission, these were transient exceedances, and I don't mean to minimize them. We take them very seriously, and we've corrected the condition that led to that happening. But it looked like there were several days where this happened for moments at a time, or whatever it was, but those, as far as and maybe, don't mean to mention his name again, Mr. Cooper has something different, but I don't think they have recurred since then.
And just for the record, those were 2 questions in one, so this is my last question.
I don't know if I got both questions, Commissioner. So if I failed to address it, please let me know. I'd be happy to do my best.
Just that it happened briefly and that it was, there was some reference to it not exceeding the 75 megawatts that much.
I would say, Commissioner, with all due respect, those things those just aren't defenses to whether the Siting Act applies or not. It's kind of like saying, officer, I was only going 85 for just about 2 miles.
Right.
I mean, I think you'd really have to hear, these are good lawyers, but we're all lawyers.
Right.
We're not engineers.
Right.
Right. To answer that question truthfully, to really get a candid response on how long this exceedance was, there was no immediate alarm that went off. There was no immediate correction. I think Mr. Sharp would testify he was worried. He didn't know how much it was going to blow through the once it went through its interconnection, then once it went through 75, he just knew it had a 103 DC rating, didn't know. Called over, still gets no response.
Understood.
So I think I think there are 42 solar generating facilities that are on Dominion's system. Should an occurrence like this happen not on a September day, would we be talking about something different? And would we say, well, this was just a minor, don't worry about it? I mean, what happens if we had a number of plants at more of a critical time that all had this sort of issue in exceedance and a cumulative effect? Could have had a much bigger, I mean, this is not, we're not playing Legos. These are people, these are large transmission lines, and 75 megawatts is not an insignificant amount of power to generate. I mean, you're talking about cities.
And just for everybody who maybe thinks I'm asking questions I shouldn't ask, to me this relates to the exchange that I had with witness Cassis and with witness Hopkins, as well as others had. And to me, this is potentially new evidence that clarifies some of that conversation, and that's why I'm going for it.
Commissioner.
Yes, please.
I think the exchange you had with Mr. Cassis actually illustrates why this is cumulative. I mean, we could be coming back to you. I mean, we have hearings. Mr. Cassis comes to a hearing. He's aware, I think he testified to 5 exceedances. So the possibility of exceedances was known to everybody at the hearing. If Dominion wanted to offer details about those exceedances, it was in a position to do so at the hearing. So now we have an example of another exceedance. That's why we say this is cumulative, because there's nothing new here other than, okay, we have an example of an exceedance. We could do this all year. If everybody comes in and says, well, I found an example of something we talked about at the hearing, I'm sure we could do that too. The hearings would never end.
Understood.
That's the reason for the cumulative evidence argument.
Okay. Thank you. No further questions.
Commissioner Caston?
Thank you, Madam Chair. And I've heard Mr. Hopkins' name mentioned a few times, and testimony transcript, even heard mine mentioned a time. So I read through the transcript in detail. I remember asking certain questions. I remember the words I used. And when I didn't, I kind of looked at the transcript and I saw exactly what I said and exactly what the response was. And having looked through this motion from Ceciba that you mentioned, Madam Chair, I must really be honest. I do have a technical question or two I'd like to ask someone. And despite the august group we have here, and I have great respect for you all, and if Ms. Mixon was here, it would make this group look much better. I don't really want to ask you all these questions. So depending on what we do, I'll...
Thank you. Commissioner, at this point, we're just trying to determine whether or not to grant the motion to reopen the record. We shouldn't be delving into the factual, the basis for the motion. We're just here to determine whether or not, and so any questions need to be related to the arguments of the council, not the underlying facts of what the motion purports. Commissioners, anything further?
Madam Chair, I don't have any more questions. I don't know if commissioners have any more questions or not, but I do have a motion.
Commissioners, any further questions? Hearing none. Commissioner Williams?
Madam Chair, fellow commissioners, I move that the commission deny the motion to reopen the case. I understand why the motion was filed. And, I'll get into that in discussion. So my motion is to deny the motion to reopen the case.
Commissioners, we have a motion to deny the motion to reopen the case. Any discussion?
Madam Chair?
Commissioner Williams?
As a former trial lawyer, there's nothing more exciting than a smoking gun. And with information like this being presented, there was a thought initially by me that maybe there could be a smoking gun, something new that the commission did not hear, did not see, didn't have an opportunity to consider. But here, from my understanding of the motion filed and the information presented to the commission, yes, we didn't know exactly what happened with the Eastover facility on September 5th. And yes, we didn't know what the operator at the solar desk saw on that day. And I commend everyone involved for reporting the information up. But I believe the record is clear that there were instances of facilities operating over 75 megawatts. I think there was detailed discussion about that. And not only that there were instances that occurred, but in those instances, there was a course of action outlined and laid out for what should happen if and when it did occur. And quite frankly, we went into that, we went into those lines of questioning so deeply and so thoroughly that I'm really not surprised as to what I'm hearing here today, because it seems as if we discussed it already, which is why I wanted to understand what exactly was new about it. I agree with Attorney Tarini. There are situations like this that could keep a case going for an extremely long time, in perpetuity possibly. Again, I give credit to the operator that identified this issue. I give credit to Dominion and their counsel for filing the motion and bringing it to the commission for us to consider. I give credit to the commission for being flexible, for expediting this motion hearing and the parties being prepared to go forward. But I can't see where this meets the standard of it being new evidence for the commission to consider, which is why I think it's appropriate to deny the motion. And obviously, as I am not an engineer, an accountant, or anything other than a lawyer, I'm definitely looking at this from a legal perspective and a legal perspective alone. But I would love to hear from my colleagues that may have another perspective that could help me see things differently. Thank you, Madam Chair.
Thank you, Commissioner. Commissioner Caston, your light's on.
Thank you, Madam Chair. And thank you, Commissioner Jay Williams. I certainly am not looking to make this any more complicated on any of them, anyone. Don't want to prolong anything unnecessarily. But from the technical point of view, Commissioner Williams, especially, after having read the briefs and the emails, at least from my perspective, I think it's clearly new information. There's some technical things, and maybe nothing. It may absolutely be nothing. But I'd like to ask the technical questions of someone technical, because this concerns me. I got a question on this. How can this be? But I can't ask it if we don't do this. I do think, all things aside, this email chain and just kind of the math I went through and the things looked at, I do have a concern, or at least I feel like questions should be asked and answered. Now, again, I'm not trying to prolong anything, and I don't want to make this any more complex for the commission or any of the parties. But I can't ask the questions if we don't at least allow us to ask the questions.
Commissioners, any further discussion?
Madam Chair,
Commissioner Thomas?
I have an alternative motion. I move that we place this for a vote on the next business meeting.
Which will be this coming Thursday?
Yes.
Okay. We have a substitute motion on the table to place this matter on the agenda for this coming Thursday's business meeting. We'll take up any discussion on the substitute motion. Hearing none, we'll vote on the substitute motion. Commissioner Thomas?
Aye.
Commissioner Justin Williams?
I respectfully vote no.
Commissioner Carolee Williams,
Aye.
Commissioner Caston,
Aye.
Commissioner Irvin,
No.
the chair votes no. The vote is 3-3. The motion fails. Hearing that motion having neither passed and not having passed, we'll return to the main motion, the original motion. Is there any further discussion? Hearing none, we'll proceed to a vote. Commissioner Justin Williams,
I vote aye.
Commissioner Carolee Williams,
Aye.
Commissioner Caston,
No.
Commissioner Irvin,
Aye.
Commissioner Thomas.
No.
Chair votes aye. The motion carries, and the motion to deny the motion to reopen passes. So the motion to reopen is denied. Is there anything further from the parties this morning? I'd like to thank all the parties too. Dominion, I appreciate y'all bringing this to the commission's attention. I really do, and I appreciate all the parties working so quickly and on expedited timelines to file their responses and then replies. I know y'all are busy. We've got a crazy schedule here at the commission, and a lot of y'all are involved in that. And we don't take, or I don't take, when things are expedited beyond or quicker than the rules allow, when we waive to require expedited replies and responses. I don't take that lightly, because we know that y'all are busy too, but we're trying to move through a lot of work here. So I really appreciate and would just like to thank the parties for working so hard and so diligently and accommodating us when we do ask for these expedited responses. So thank you very much. It is much appreciated by the commission. If there's nothing further to come before the commission, we'll close this proceeding, and everyone have a good afternoon. We are adjourned.